Guest that I have is Mr. Mark Gommesen.
Good evening. My name is Mark Gommesen. I live at 3421 Livingston Lane in Carrollton, Texas. Ms. Chaffin, Dr. Burns, members of the Board of Trustees, I address you tonight not in support of a principle spelled P-R-I-N-C-I-P-A-L, but on a principle spelled P-R-I-N-C-P-L-E. I address you in support of open government. It is my unwavering belief that government should be conducted in the bright, sanitizing light of sunshine. Madam President, according to Section 551.042 of the Texas Government Code, if at a meeting of a governmental body, a member of the public or of the governmental body inquires about a subject which notice has not been given as required by the Open Meetings Act, the notice provisions of this act do not apply to a statement of specific factual information given in response to the inquiry. It is my intent to make such an inquiry and request respectfully that you make a response. Madam President, I make the following inquiry. I have carefully examined the minutes of this body, and I am unable to locate where this board acted to instruct legal counsel to take action in the Fifth Appellate Court on behalf of the board. Madam President, I inquire where in the minutes of this body of the Board of Trustees gave instruction to legal counsel to take action in the Texas Fifth Appeals Court. Further, I seek assurance from the President of the Board of Trustees that the Board did not act in executive session to instruct legal counsel to file an appeal in the court, in the appeals court. Under 11.151 of the Texas Education Code, the Board must act as a corporate board. Madam President, as you are aware, under the Texas Open Meetings Act, decisions entrusted to the Board of Trustees must be made by the body as a whole at a properly called meeting. A properly called meeting requires the meeting be conducted in public, follow a published agenda, and the majority of the members be present. Any action of the board requires the majority vote of those present. In the current action, the Texas Court of Appeals, the school district, is the appellant. An appellant is defined as the party who initiates the appeal in the higher court from a decision in the lower court tribunal. Madam President, for the district act to act as an appellant, it requires a formal action of this board. The Board of Trustees is permitted to consult with attorneys in executive session, but the board cannot take action as a board in the executive session. The Texas Open Meetings Act only permits the Board of Trustees to seek the advice of attorneys about pending or contemplated litigation. In the many months of litigation, I can only find one time when the board took action to instruct legal counsel to take action on its behalf. At September 10th, at the regular meeting, Mr. Shore made a motion to expedite the litigation in the 95th District Court. It is interesting that the court that
is your 3-minute timer. Can you?
It is interesting that this 95th District that this board would take a motion to expedite action in the 95th Court, but not felt necessary to make a motion to take action in the appellate court. This motion clearly was not a motion to exercise an appellant, to instruct the legal counsel to file an appeal on the 95th Court decision. That was not what the agenda item was that night. Okay, under the Texas Open Meetings Act, the Board of Trustees cannot take only actions on those.
Mr. Gommers. Mr. Gommers.
Can you give me just a little bit more time?
Can you wrap it up in 30 seconds, please?
Yes, ma'am.
Thank you.
Under the Texas Open Meetings Act, the Board of Trustees is going to take action on those items identified as actionable in the official agenda. At that meeting, the appeal was not an actionable item on the appeal. Also, that motion was made 11 days prior to the decision in the district court. It would be unreasonable to believe that this board would make a decision to make an appeal without knowing what the final ruling in the district court was going to be. I also have other items which I can submit in writing if I may.
Please submit them in writing.
Thank you, ma'am.
And yes, sir, you are correct. All deliberations, decisions, and actions and directions must take place in open session. And the reference that you quote is, in fact, the reference that was discussed during closed session as we discussed the entire case around what we were looking at. And when we came out of closed session, Mr. Shore did make a motion to expedite resolution, knowing that there might be some appeal or some decision, that we would have instructed our legal staff in order to move forward to get an expeditious resolution. That was the objective, and it was a unanimous vote.
Madam President,
Now, we can't discuss, I can make statements of fact, which is what I made. Other than that, we are not allowed to discuss things that are not on the agenda. So we can't do discussion.
Madam President, I make the inquiry that you read the motion. The motion clearly states, refers to Ken Moberg's court. Also, I point out, Madam President, that Trustee Webb voted for that motion, and she clearly is opposed to any appeal. Madam President, I point out that when that motion was reported in the media, it was reported as a motion to expedite action in the district court. Madam President, I point out also that the language of that motion was vague and unclear.
Thank you.
Madam President, Mr. Gommesen, point of information, Mr. Gommesen made some very interesting points.
We can't discuss this. It is not on the agenda.
Madam President, I have already pointed out, you can discuss a question of inquiry as long as you respond only on the facts.
That is correct.
All right, let's.
That is correct. Mr. Gommesen made some very interesting points. In all the previous minutes, can you please point to a motion made in open session that gave the attorney direction to appeal?
We'll go back, we'll pull those.
Madam President, I'll be happy to respond to that.
All right, I beg your pardon?
I'll be happy to respond to that. The September 10th motion that I made sought an expeditious resolution of a legally final decision. And legally final includes all levels of appeal.
No, legally fine. It was, again, if you read back your motion, it was referencing Ken Moberg.
I made the motion, Mr. Gommesen.
And I have read the motion.
And I made the motion.
Okay. And also,
legally final includes a final decision.
No, sir. Judicially final decision means that.
Legally final includes levels of appeal. That is a statement of fact and law, sir.
Madam,
can I address Ms. Webb, please? Ms. Webb, was that your understanding of that motion?
I took it to mean as the final decision, as in Ken Moberg's court.
and Madam President, in appealing the judge's decision,
Mr.
possible.
Okay,
Can I make one more point, and I'll be quiet, if you'd be so generous?
all right.
The agenda item only referenced the 95th District Court. For you to take action beyond the action of the 95th District Court, or you refer to an appeal, okay, Mr. Shore, and you know what I'm talking about.
No, I don't, but that's okay.
Okay. The agenda item only addressed the 95th District Court. The only action you could take at that meeting could be an actionable motion regarding the case in the 95th District Court. You could not take action beyond that. Otherwise, you are in violation of the Open Meetings Act.
I think that is something for a
Now,
legal opinion outside this room and outside this body.
Okay, Ms. Chapin, I did call the State Attorney General's office, and they did inform me that it would take a separate motion, clearly stating that this board wanted to take action in the appellate court.
Okay. Mr. Fleming.
No,
All right.
I'm just saying the language that was used, expeditiously as possible, that's kind of vague. I mean, I'll take that as to say, okay, after the 95th District Court has ruled, then whatever the case may be.
An appeal is not expeditious. This takes about 8 months. Is that correct, Mr. Shore?
I think that's pretty
You
ambiguous.
I'm not
promised.
certain that we can discuss this. I'll be happy to visit with you after, Mark.
Yeah.
Well, it's ambiguous language is basically what we're saying. So there's really nothing that says.
Okay. All right, thank you. Thank you, sir. Mr. John Bloomer.